Well, maybe you can help me on McCullen v. Coakley. And so here's the big McCullen v. Coakley. Just to summarize, it is a case that came out of Massachusetts. Massachusetts dealt with violence at abortion clinics. They found that the bubble means of protecting women going into abortion clinics, in other words, a sort of a floating imaginary force field that could not be legally penetrated by protesters around a woman, 6 feet, I think it was, around a woman entering into a clinic, or men, I guess, for the matter. But they came up with a solution 35 feet from a clinic. Basically, they draw a line, and that way police can make sure that nobody is crossing that line in terms of their protesting or what the Supreme Court would call counseling. And this was struck down. First of all, talk a little bit about, and this was a majority opinion, which I find, I mean, here's the part that I can't reconcile. Then people have talked about this. How is it the Supreme Court has a buffer around the Supreme Court? How is it that we have free speech pens? How is it that if you're union picketing a business, you have to be X number of feet away? I don't understand this.
Yeah, Dahlia Lithwick at Slate, who I assume many of your readers will read anyway, had a great, made that point yesterday that the buffer zone around the Supreme Court is massive. Basically, the whole, if anybody's ever been to the court, that whole plaza in front of the court is basically blocked off from any, for reasons of decorum, and so that the reasons are actually less compelling. With reproductive clinics, you're talking about, harassment, vandalism, other things, whereas at the Supreme Court, it's pretty much just, it makes us uncomfortable when you protest, which is so the state reasons are much less compelling. One thing to mention here, though, is that what I think, and again, we have another, and this is sort of the third case I've taught you in a row where this is the case, is that although the court was unanimous in its judgment, it was very badly split on the rationale. There was a 5-4 case in terms of why the buffer zone was unconstitutional. And one thing I really want to emphasize here is that the Supreme Court did not rule that buffer zones around reproductive clinics were unconstitutional. That essentially Roberts' argument was, so that in a 2000 case called Hill versus Colorado, a buffer zone was upheld. And I was concerned because basically two of the people in the majority, Rehnquist and O'Connor, were replaced by, of course, by Roberts and Alito. So there was the possibility that it could be overturned. Alito pretty clearly wants it overturned, but Roberts was actually the swing vote for the majority here. And so, at least on its face, what Roberts said was that buffer zones, are potentially constitutional. The state can protect access to reproductive clinics. Roberts also ruled that the buffer zones did not discriminate against anti-abortion speech, and that's a very important point, so that they're not subject to strict scrutiny, so that the argument had been that because there's a buffer zone, but employees, for example, and patients are allowed within the buffer zone, that this discriminated. And the majority said, well, no, that's silly. There's good reasons why employees can talk, in front of a clinic, but, not everybody can, so that I want to make clear that the Supreme Court did not rule that buffer zones in principle were unconstitutional. All they said, was kind of like this Massachusetts one, which was novel, just went a little bit too far. That essentially what the court argued was that there were ways of protecting access that allowed for more speech on, and there's a particular focus on public sidewalks, that kind of thing.
What was the quality of the buffer zone in Massachusetts? What aspects of the quality of the buffer zone that made that unconstitutional, if in principle the idea of buffer zones are not problematic?
Yeah, basically, as I said, that the real key seemed to be, first of all, that the zone was a little larger than the ones that other states used. And as I said, Roberts, and there was kind of one exception that, and of course, all these buffer zones sort of depended on how exactly the clinic was configured. So that there were a couple where the clinic was set off, I think the one in Worcester where it was set off from the street, but there were the ones in Boston, I believe, were sort of right up against the street. So what the majority held was that essentially because the zone was relatively large and extended on to not just the front of the building, but kind of onto the public sidewalks surrounding it, that it sort of interfered with forms that are traditionally associated with free speech. So that essentially it went further than it had to protect the legitimate interests at stake. So that was essentially, I mean, as most students of the court know, the court tends to be sort of very uncomfortable with outliers, that a lot of what the Supreme Court does is, if the state is doing something differently that implicates a constitutional right, it's always going to be a lot harder for the state to justify that. And that sort of seems to be what happened here. Now, I'm not really convinced by that. I probably would have been a solo dissenter in this case. But having said that, it could have been a lot worse. And we'll see going forward. But at least, it did uphold buffer zones as a principle. But that at least seemed to be the argument, that the Massachusetts one went further than other states had, and at least they didn't convince the court. And again, this includes not only Roberts, but somewhat more surprisingly, Justices Ginsburg and Sotomayor and Kagan and Breyer, that it was necessary to go further than say Colorado did.
Okay, so two things. One, I have to say this as I'm a native. It's Worcester.
Oh, Worcester. I'm sorry.
That's
Worcester.
all right.
I'm sorry.
Right.
I'm sounding like a hick there.
I lived with the indignity for too long. And two, so if I understand what you're saying, that because in this instance the 35-foot buffer zone cut so deeply into the public sphere, I guess, in terms of like sidewalks, and that made it particularly onerous to free speech.
Right.
And so, okay.
Yeah, that seemed to be the logic.
And they had to maintain that notion of back to the Dahlia Lithwick question, and then sort of my question about like the unions. How are those reconciled, or is it just simply is it a function of the qualitative of the size or the nature of the buffer zone, or is it because they're reconciled because of the nature of the Supreme Court or the nature of a union strike versus a business?
Yeah, it's always, and again, this is sort of a very difficult, that these kind of space-time and matter restrictions are really difficult, and they're obviously sort of mostly judgment calls. Of course, the Supreme Court has never issued a full opinion about its own buffer zones. So I would love it to actually, because if you ask me, those buffer zones in the plaza strike me as unconstitutional.
Let me just explain what you mean by space.
I understand that justices need more protection, and
right.
I guess to me, I don't think you can. I don't think that basically I don't see how that whole area around the plaza, as opposed to the interest, has to be cut off from protest. I just don't think that. So as far as I can tell, that violates the First Amendment.
All right, and let me just
so I would love to know how they would.
Let me just explicate what you mean by space-time and what was it? Space-time and matter. Is that
space-time and matter?
Yeah. So in other words, I can protest, but if I do it at 3 a.m. in the morning, I'm yelling at the top of my lungs. I can get like a noise violation.
Yeah, that's exactly. So that the idea here is that obviously there's no question that these buffer zones restrict speech. I mean, that's obviously not in any dispute. But that doesn't necessarily end the question, because this the state is allowed to do things that burden speech in order as I say, if they restrict the space, time, and matter. So that as you put it, that's exactly right. That you have the right to express your political views. That doesn't mean you have the right to go to somebody's apartment and express them at the bullhorn at 3 a.m. That localities are allowed to sort of pass things for the public order. And the two key things is that if these are going to be constitutional, they first of all have to be viewpoint neutral. That is, that they can't be so that when this is what led to the letter from Birmingham jail, when you deny a parade permit basically to suppress somebody's views, that that's not consistent with the First Amendment. That these things have to be both neutral on their face and applied fairly to all sides. So that's the first thing. And then the second thing is that they have to be the least restrictive means. That is, the state has to show that it has no other way of accomplishing these things without burdening speech. And so what the court found in this case was that the buffer zone, even the Massachusetts buffer zone, was not viewpoint discriminatory, which is very important going forward, so that it argued that they didn't discriminate against anti-abortion speech. What they did find was that it wasn't narrowly tailored enough, so that basically the court said the state's interest in protecting women's access to clinics is legitimate. The state did not discriminate against anti-abortion speech, but it could have address these interests in ways that were not as restrictive of speech. And that's essentially what they found. So that it passed basically the first prong of the test, but it failed this kind of second, more narrow one.
Scott Lemieux, Lawyers, Guns, and Money, also at the American Prospect. Thank you very much. And, it's... all is forgiven in terms of the Worcester thing. I'm over it now.
All right. Thank you. I will make sure to have all of my New England pronunciations up to snuff by the time I'm
what really bothers me about it is that even the airplane code for Worcester is ORH, and there is no H in Worcester. Sorry, had to get that off my chest. All right.
Fair enough. I always learn something. Thank you very much.
Thanks, Scott.